Good afternoon. My name is Guillermo Patino, the Chairperson Designee of the New York City Loft Board. Welcome to our June 15, 2023 public meeting. Section 282 of the New York State Multiple Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of inter-multiple dwelling units, from commercial and manufacturing spaces to legal residential units that comply with the minimum standards of safety and fire protection in Article 7B of the New York State Multiple Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of legalization, and prosecutes parties who violate the Loft Law and the Loft Board's rules. We'll first turn to a vote on the minutes from the May 18, 2023 public meeting. Are there any corrections or comments to the minutes? Seeing none, is there a motion to accept the minutes? Thank you, Ms. Rajan. Is there a second?
A second.
Thank you, Ms. Otto. Mr. Barrett, can you please poll the board members?
Mr. Hilton.
Abstain?
Mr. Delaney.
Yes.
Ms. Roseland.
Yes.
Ms. Otto.
Yes.
Ms. Rajan.
Yes.
Chairperson Patino.
Yes.
5 in favor, 1 abstain, 2 absent.
Thank you. So next on the agenda is the staff reports. We'll start with the report of our executive director.
Good afternoon. First is an update on personnel matters. It's my pleasure to introduce Alice Chung, our new summer law intern. Alice comes to us from Fordham University School of Law, where she's finished her first year in law school. Welcome, Alice. Also, regarding personnel, I've participated in several rounds of interviews for our paralegal positions. So I'm hopeful that we will have 2 new paralegals very soon. Next is litigation. I sent to you, I believe, the Monday, was it this Monday? Feels like ages ago. But after the delivery of the materials for the board meeting, I sent you a recent decision that was issued by the court. The tenant at the 3rd floor at 120 Waterbury Street filed an Article 78 petition challenging order number 5184, which denied loft law coverage pursuant to MDL 281-6. In upholding the board's order, the court agreed that the board's finding that the evidence in the record showed that the 3rd floor was occupied as communal living space, and the occupants did not live independently as required for coverage. The last point in my report is more of a public service announcement, one that I'm sure Ms. Story will repeat, but I think it's worth repeating. We have 2 important deadlines coming up for owners. First is legalization progress reports that are due on July 1st. Owners are required to file complete reports. The reports must be signed by both the owners and the architects. The reports can be filed by email, so I won't completely take over Ms. Story's report, but she will provide the email. So I will caution owners who miss this deadline. These reports are important, and we will be reviewing them and considering who to file enforcement against. So I would strongly encourage architects to accurately represent their progress on legalization and owners to review what is being reported. Also due on July 1st are the building registration renewals. Building owners are required to complete the registration application and the emergency contact information. Again, very important for the Loft Board staff to have the most updated information. If there's any emergency in one of our buildings, we have to have the right contact information for the building owner. Also important is in the context of enforcement. This information will be used in delivering notices of violation and other correspondence from the Loft Board. Failure to meet these deadlines will lead to enforcement. And that's my report. Any questions for me?
I have one question. I have a couple other questions on the other reports, but we'll get to those eventually. Last month, you provided statistics again 6 months after you had provided them in November, so we have November and May. And your listing of the buildings that have met fire and safety standards is 7B, buildings that have met the permit deadline, and buildings in the narrative statement process. Those three figures totaled 220 in November and totaled 247 in May of this year. And I gather we have about 323 buildings currently in our universe. So that leaves like 80, 90 that don't fall into those three categories. Some of them are more advanced in terms of having a C of O, and or where are they?
Good question. I would have to report on that at a future meeting. I would have to take a look at where exactly they would fall. I mean, some of these buildings have C of O, some of them are by-C buildings, and some of them are, I don't know. I would
Okay.
have to go back and take a look.
Okay, it would be helpful sometime to get a further breakdown. And I guess along those same lines, you said at a future meeting, I note that you advised us in the email providing the cases for this month that we're not going to meet in July. And we traditionally take August off, so that means we won't be meeting again for 3 months. Which, as I expressed to you in an email, I find concerning mainly in terms of making progress, particularly with regard to getting feedback for you all on the fact sheets that you're working on. And I see there are no new ones this month, so I'm sure that's because you've been busy with other things, but I just wonder if you've given any thought to how we can keep the momentum going.
We discussed internally about still delivering the fact sheets right around the time of the July meeting. We made the changes that you suggested to the no fact sheet, and we created the sale of rights fact sheet. It was too short of a time before the board meeting that we thought it wasn't enough time for you to review. So instead of just sending the email, we thought perhaps after the board meeting we will send the fact sheets, right? So we'll send those fact sheets back to you either tomorrow or early next week. And we will continue working. We've been talking about the narrative statement fact sheet and how we're going to break it up in ways that it makes sense. Work is continuing, and what we can commit to doing is sending those fact sheets to you right around the time that we would have had the July board meeting. So if you want to send it back to us and, with comments or suggestions about anything, that's perfectly fine.
And to do that appropriately, it should just be correspondence between single board members
Yes.
and the staff as
Yes.
opposed to
A group.
a grouping.
Yes.
Yeah, okay. All right, thank you.
Sorry, I stole your thunder.
No, you totally did.
Okay. I stole yours. Okay.
We're a team.
Any more questions for me?
Not at this time.
Okay. All right.
Thank you, Executive Director Cruz. Good afternoon, board members. A lot of what I was going to say, the Executive Director just covered, so I'm not going to be redundant and I'll just try to fill in what was not covered. I was going to give an update on the fact sheets that the staff members are creating. They provide an overview of the information and information about specific areas and functions of the Loft Board. Last month, we received great feedback on the narrative statement fact sheet. We recognized that board members would like more information than was originally provided in our first draft. So we've been discussing internally, as the Executive Director said, and with all the additional information that we're considering now, The fact sheet might now look somewhere between 5 to 7 pages, rather than the original 1 to 2 pages that we're considering. We continue to work on this, obviously, and as I said, the narrative statement fact sheet will be the most difficult fact sheet for us to create. Last month, we also discussed the Lono fact sheet. We took the feedback from the board and made some modifications. We believe that the Lono fact sheet is now complete. We will send that to the board members after the meeting today, the Lono fact sheet. And as the executive director said, we completed a sale of rights and improvements fact sheet. This fact sheet gives an overview of the sale of rights and improvements process, how to properly file the sales, and the effects of the sales. So we'll send that draft over to the board members as well after this meeting. We are finalizing a cover letter that will accompany the fact sheets when we mail them out to the libraries and community boards. So we're finalizing that cover letter, and I can tell you that the next fact sheets that we're going to be working on, including the narrative statement, obviously, we're going to be working on the rent and milestone increases, and also the maintenance and minimum housing standard fact sheets. Those will be the next 2 fact sheets that we'll try to tackle. The remaining fact sheets, after we complete those, we only have a code compliance fact sheet, an access fact sheet, and we are considering a fact sheet just for applications and how to properly file applications with the Loft board. So those will be the rest of the fact sheets that we have. If the board members think of additional fact sheets that might be helpful to create, they can always contact us, and we'll be happy to see if we can put something together. And are there any questions?
When you send the revised and/or drafts of the new sheets, can you also can you just send everything you have again in one, so it's all in one email?
Okay, like the old and the new? Is that
Yeah.
what it is? Okay.
No.
Oh.
Two new ones.
Oh.
There are a few fact sheets you did not make revisions to, correct?
Correct, yes.
Yeah, so all of the fact sheets that you have complete, whether they're 100% complete or in process, just so they're in one email, if it's not too much trouble. I know it's just a couple extra attachments.
Sure, that would be 4. So, oh, do you also want the incomplete narrative statement, the one that we're? No.
Apparently not.
Okay. So yeah, that's no problem.
Just so we also have the latest, because sometimes going back through emails causes confusion. That's all.
Sure. Any other?
One thought just occurred to me. Undoubtedly, there will be reasons because of changes in the rules or changes in state legislation or case developments that fact sheets will have to be revised. So maybe it would be good to put a little release date at the bottom of every one, so that if 2 years from now somebody can see that the one they've been relying on is an earlier version than the one that's currently up on the website. That kind of.
It's a good idea. We'll add that. Thank you. If there are no further questions, we'll turn it over to Florence Oyegwe. We were talking about the sale of rights, so she's been going through the sale of rights, and we asked her to comment on what she's been seeing, and she will present that to the board members.
Good afternoon, all. Thank you, Mr. Kirk. We currently are making progress in reviewing and approving the sales of rights agreements. However, there are delays in processing a good number of sales of right filings due to avoidable errors or omissions. So to avoid rejection or delays of your sales filing, please, we enjoin you to ensure that the consideration amount on the sales agreement is not redacted. Also, provide us with unredacted proof of payment of the sales price. Also, to prevent a fine, the sales record form must be filed with the Loft board within 30 days of the sales. Any questions?
I have one question. How much is that fine if they do not timely file?
It's $4,000.
Thank you.
Thank you.
Thank you. Next is an enforcement report from our enforcement attorney, Ms. Renee Story.
Thank you, Mr. Clark. With regards to our reasonable and necessary enforcement, we have issued 129 violations so far. 57 violations require fine determination. 36 are new violations. We've been receiving some really good responses from some building owners. Some have already filed answers and complied already. And some have even reached out to us concerning scheduling conferences. Then we also have a remaining 21 violations where administrative determinations need to be sent out. Our goal is to send those out either tomorrow morning or at the latest next week. With regards to the legalization reports, we have received a total of 150 legalization reports since April. We have issued 9 violations. Most of these violations was in connection with other violations that we were already issuing. I do a whole, I'll review the whole building and see if there's any violations and then issue them for each category. But we are expecting to beef up that number in July. So to the executive director's point, please ensure that these reports are emailed to us or sent to us by mail or delivered to us in person. The email address is loftboardquarterly@buildingsnyc.gov. With regards to sales of rights, we have been receiving some referrals from Ms. Florence concerning possible violations. So far, we have issued 5 violations. 4 of those violations have been answered and paid. We are waiting for the remaining violation as we just issued it. With regards to housing maintenance, we have brought oath actions against 2 building owners. We have attended some settlement conferences in which both building owners requested additional time to comply. Those requests were granted. We have, they have into the settlement conference to provide proof of compliance. The settlement conference for the first is July 12th. That's 5 to 7 Mercer Street. And for 117 to 119 West 26th Street, their date of compliance is July 31st. We have also conducted another reasonable and necessary conference. We are waiting for the owner to come into compliance. They have scheduled a meeting with the DOB to do further action with regards to legalization. We have 3 new requests from building owners, 1 from a prior violation and 2 for new violations. And back to our public service announcements. Okay. We are doing our annual building registration. These notices, these packets will be sent out the end of this month for certain. If you do not receive a packet, please reach out to the Loft board. Our number here is 212-393-2616. We are located at 280 Broadway, the first floor atrium. New York, New York 10007, just in case you wanted to be able to mail it in instead. If you guys do not receive your registration packet by July 4th, please, please, please reach out to the Loft for it. Also, very important with regards to that, we are also sending forms that will allow the owner to update their contact information. Please take advantage and update your contact information. If there's a new owner, please make sure that we receive the company deed with the application. Last, the IMD notices. We want to make sure that each owner knows that they are required to have an IMD notice in the lobby of their building. That notice must include the building's address, the IMD registration number, the contact information for the owner and managing agent, and the Loft 4's phone number and email address. A fine for not having these signs posted in the building 5 days after you receive your IMD number is $1,000. We are looking into possible enforcement there, so owners, please be in compliance. Any questions? Yes.
Thank you for your report.
Yes, sir.
A couple of questions. Number one, the failure to file quarterly reports. If violations are issued, will those result in fines?
It depends if they become compliant, because
Right.
they have a 30-day compliance period. If they become compliant, no, we're not going to issue a fine. But right at that 31-day, I'm looking to do administrative determination issuing fines because
And
they have more
what
than
would
a
the
fine.
fine range be?
The fine range, I believe, is $1,000.
Okay. In terms of the building registrations,
Yes, sir.
how are we sending those now?
The building registrations, we're sending it out by mail. The mail out date is about June 22nd.
Physical, postal, snail mail?
Yes, it's gonna come right in the mailbox. They're gonna have an opportunity to fill it out because we need the originals. So sometimes people can't print it out, whatever the reason is, they'll have the original form in the mail.
Okay, great. And lastly, I am so impressed with your reports and also Mr. Kim's that, I'm starting a collection. So it would be great if you put the data on it.
I certainly will, and I will put it on the top
That'd be nice.
so you can see it. I apologize for the confusion.
That's okay.
Any other questions, guys?
Are some of these fines ever cumulative? So if there's, say, the posting the IMD number, right? If it goes on for longer, is there a second fine, or is the fine reissued, or if it goes up and comes down?
That's an excellent question. So what I've been noticing is we don't have an opportunity or need to reissue, because once they get hit with that initial fine, they are like, oh my goodness, whatever you need, I'm calling you directly. So that's thankfully, we don't have any. I will have to definitely double check and do some legal research as to whether or not we can issue multiple fines back to back and that, but we haven't had the opportunity to do so because they haven't come into compliance once they're hit with the fine or once they even see that it's a possibility of a fine.
Thank you.
Did you want to say that?
No, it's okay.
I can tell. We
Well, I was gonna say that the only cumulative fines that we have are failure to register and housing maintenance. If, for heat, if this is your second violation within the same heat season, it's not the same fine as the original violation. Those are the types of fines that we increase by,
Right.
behavior that's not in compliance.
Housing maintenance stuff.
Housing maintenance stuff and the failure to register for multiple years.
Any other questions, guys? Thank you, guys.
Thank you.
Thank you. And the last report is from Mr. James Kim, our legalization attorney.
Good afternoon. In front of each of you are updated statistics of the buildings that are currently in the open narrative statement milestone of the buildings that are under Loft jurisdiction. In the last month, as always, several buildings have moved along in the legalization process. We received new narrative statement filings, held narrative statement conferences, reviewed requests for certification following the end of several clock periods, and followed up on several buildings that have been inactive for some time. At the last meeting, I brought to the board and the public's attention 3 topics, including 1, buildings inactive in the legalization process, 2, incorrect and incomplete requests for Loft Board approval letters, and 3, the increasing number of alternate plan disputes we have been seeing as of late. This month, I would like to discuss 1, another check-in on those inactive buildings, 2, legalization filings, and 3, the administrative difficulties that have arisen in the alternate plan process. Inactive buildings. After several internal meetings, Loft Board staff has decided that we will schedule conferences with the owners of record, tenants, and the last known architects and/or professionals associated with the building. These conferences, together with enforcement action that we have already taken, should spur them to action. If it does not, we will issue more enforcement. 2, legalization. Building owners continue to file more and more legalization filings with us, that is, plans and narrative statements, indicating that owners may have gotten the message that they can no longer delay with their obligations. We ask everyone to be patient as we review and process these submissions, both administratively and substantively. That being said, we have also seen professionals on both sides seek delays and/or postponements for various reasons. We acknowledge that within the small industry of legal and design professionals who work on loft buildings, many of them have gotten quite busy with projects by all these owners. But granting delays and postponements is extremely resource intensive upon Loft Board staff, and individual owners are responsible regardless of who they choose to retain. Number 3, as a quick refresher, both Loft Board approval and DOB plan examination are 2 separate but required tracks for all applicants seeking to do legalization work in Loft Board buildings. As part of the alternate plan dispute process, professionals have brought to our attention that much, if not all, of the existing infrastructure and procedures for DOB plan examination is oriented from a building owner's point of view, not the tenant's. However, much of the purpose of a tenant's alternate plan filing is to go through DOB plan examination to demonstrate and or prove that their alternate plan is also code compliant and can serve as a viable legalization plan. We have had some meetings as of late with plan examiners in various boroughs to educate them on the alternate plan process, and will continue to do so. Some ideas that have come up during this process. 1, having the same plan examiner examine both owners and tenants' plans as they are already familiar with the building. From a past meeting with plan examiners, it doesn't sound as though it may be possible to implement policies for supervisors to automatically assign the same plan examiner to both, but they can upon request. Forms and documentation. As I've said, much of the forms and documentation, both within DOB and other agencies such as the LPC, contain affirmations on behalf of owners that must be completed to clear objections that arise during plan examination. However, with alternate plans, tenants who have filed alternate plans and their professionals have understandably not been willing to put their name or professional licenses to such affirmations as they are not owners. Although it is not a priority, it is certainly on our to-do list to see what we can do to help tenants. This is also a reminder for all tenants who undergo this process that they have an obligation, much like owners, architects, and engineers, to take all reasonable and necessary action to clear their objections in a timely manner. Are there any questions?
Thank you. That's a lot of information to digest. I read with interest the minutes from your presentation last month. And I just had a couple questions. You referred to, in capital letters, dispute resolution proceeding. That's the alternate plan file, correct?
Yes.
Yes, it is the it is the adjudicative process for alternate plan filings.
Right, I think it's the BP is the code. Yeah, okay. Good, I just wanted to make sure it was the same thing. You also noted, I found it very thought-provoking, and I'm quoting, however, despite all our efforts, we keep seeing the same mistakes on submissions by architects, engineers, and expediters. It's extremely resource-intensive for the law board staff to spend time reviewing submission depth, requesting more information, etc. Could you draw up for the board members a list of the most common same mistakes?
How much time do you have? No.
I hope a number of years.
Yeah, it's where to start. I mean, Ms. Dory and I, as well as the rest of our staff, we work on an administrative level with these filings every day. Again, whether they're requests for law board certifications or letters of no objection. I mean, a lot of the time it really is just simple factual things that we ask for, such as the job number for the legalization alt 1, perhaps different dates. It's sort of hard for me to sort of think.
I wasn't expecting
Sure.
you to rattle them off
Yeah,
at the moment.
there are quite a few.
No, but I think if you could, over the next few weeks, create a top 10 or top 20 list of mistakes, that would be very helpful to slowly educate the community, because I know we've seen, at least on the tenant side, retirement of an attorney who handled a lot of work. There are some new attorneys coming in. Every now and then somebody uses an attorney who knows very little about the Loft law, and sometimes some of the architects and engineers maybe a little. So if you had that kind of list, it might be helpful for people to kind of just make sure, oh yeah, job number. You know.
Yeah, absolutely. Absolutely. The only thing I would sort of add or note is that I do believe that a lot of our forms and all the documentation we've created has been very intentionally created to be as self-explanatory as possible. So it does seem to be just sort of errors or perhaps carelessness, perhaps rather than misinterpretation most of the time. But regardless, your point is taken, and we'll definitely work with that.
Good, thank you. And this is kind of blue sky territory, but the narrative statement process was created when 10 units was a huge building, and the average was 4 to 6 units in a building, perhaps. And now, because of the 281.5 and 281.6, we're seeing a lot of much bigger buildings in not only Brooklyn, but a smattering in Queens, and we have a building from the Bronx on the docket today. And it got me to thinking that there's been a regular dialogue about, well, why can't the Loft Board produce a summary or at the end of the process, and why can't we record the proceeding, et cetera, and I understand the desire to keep it informal and off the record. And I know we've just finished a massive amendment to the rules, and I'm hardly, it's just kind of thoughts that occurred to me actually from the 36,000 foot vantage point at the time I was coming back to the country. Maybe there's some way that the narrative statement conference could mutate over the next months, years, to be a little bit more along the lines of the way Oath has a settlement judge and then a trial judge. So that perhaps there's a way that the initial narrative statement discussions could be as informal as they are, but if there's no resolution, then it moves to a somewhat more formal process where notes are taken and a record is created. So that's the thought. And I really am addressing that to all the board staff, not just Mr. Kim. So I wonder if that might be something to give some thought to.
Let me ask you, isn't the current situation that, but just not maybe as stated in that way? I mean, what we have here is this informal process that people come in and talk about the owner's proposals. And then if the parties do not agree on certain things, then it moves into something else.
Right.
Right. So isn't that what we have currently?
Yes, although I think sometimes people get into start the clock, don't start the clock. I just wonder if there's a way, particularly for these bigger buildings, that there could be.
Are there any comments on this case? Mr. Delaney?
Yes. Remind me what we call the 1 o'clock meeting now.
Quasi-judicial legal briefing.
The quasi-judicial legal briefing. At the quasi-judicial legal briefing, it was brought to my attention that there was communication after the record was closed on this case from from an attorney from one of the parties, maybe also a phone call. I've raised this concern in the past that we don't seem to have clear guidelines for the public and for the professionals on this topic, and it just happened to come up. I don't know how often it happens. I know of at least one other instance, but there may be dozens of these, and I just I think it affects the integrity. It runs the risk of having people have concerns about what we do, and particularly if there are practitioners who have done this more than once. I am seriously concerned about that.
So what I would say is the law board staff, in my experience here, we haven't gotten that too often, but if we do present it to the board and try to be as transparent as possible what we do receive, and of course we do not take lightly to owners or any party communicating about a matter that's before the board. It's not proper. It should be reserved for the board members to make that final determination, and there shouldn't be any attempt to try to sway anybody, the board members' decisions prior to their vote.
Is your question, Mr. Delaney, as to whether or not there is a record kept with regard to communications either to Loft board staff or members of the Loft board outside of the usual practices?
The last time this came up, because I don't want to get into the specifics of this case from what I heard in the quasi-whatever meeting, but the last time this came up, emails were sent to several members of the board. I was one of them. So I got an email that you didn't get. That's not right. And, you know, at some point, you know, there has to be some way to make that clear.
Okay, so you want to be able to communicate to the members of the public how inappropriate that is?
And well, and to the staff as well. You know, in times past, prior to the invention of email, you know, if the board received a letter addressed to a board member about a case, they would open it, and under some staff would say, we got a letter, but we're not going to give it to you till after the case is decided. Or not tell you anything about it until after the case is decided and distribute the letter. But now, in today's world, I get an email and I open it up and I see, wait a minute, why is this person writing to me? And gee, I see that this person wrote to that one and that one, but not those two. You know, I mean, that's just, you know, I don't think we quite have the process as tight as it ought to be.
Right.
So, and the staff, you know, we don't condone that. We take it seriously. If we read something that we feel is inappropriate, then we're not going to bring that to the board's attention to have it sway any type of decision that you might be making. So, we use our best judgment. Like you said, it's technology is changing. It's just very easy to shoot an email. You don't even know what we're reading until we read it. A lot of times I open an email, I'm thinking it's a complaint or something else, and then it's, you know, I'm reading a legal issue. So we try our best to separate these things, and in transparency, we bring it to the board's attention if we need to do so.
You know, maybe there used to be times when newspapers would publish, you know, notices of violation of restaurants, and or, you know, other kinds of public records. Maybe the names of people who do this should be disclosed. You know, there should be some way to, there should be some mechanism in place or some consequence, in my view.
Taken for consideration.
Thank you.
When you receive these, is there a protocol to respond to the person and say this is not appropriate, or we just try to ignore it?
Are you talking about the staff members or the board members?
The staff members.
Usually we don't discuss it. We don't. I mean, we may discuss it amongst ourselves, but it's not something that we respond to the email or anything. It wouldn't be anything external. It would be something that we need to internally discuss.
Meaning that if it was an honest mistake, like they didn't realize, maybe it was one of the tenants or something, and they just wrote this thing.
Mm-hmm.
Is there a protocol to be like, okay, that was, actually you should do it the other way?
We actually don't know that the executive director wants to see, but we do have instances where somebody has sent something inappropriately to us, and then we will tell them on the spot that it's not appropriate. Yeah. So yes. If it's something like maybe it's a mistake, I guess it's a case-by-case basis. It's not the same if a tenant raises it as if an attorney that's been practicing for years raises it.
Right, because they should know better. Okay, thank you.
And obviously, if an attorney who practices regularly at the board calls, you don't know whether they're calling to ask about case A, case B, case D, but if it's something that's on the docket, all of a sudden you're hearing something. So it presents a problem, and it's not, you know, it's also incumbent on us. We used to have a public member who would take it upon themselves to go visit the building and look at the buzzers before it covers the vote. And it was pointed out to that individual that that's not in the record. It's not, you know, it's not like we're taking the whole jury to the crime scene. You're not supposed to go conduct your own investigation. So it just, I have that concern. I've expressed it.
I I do agree with your concern, but what I can say for the board members and the members of the public is, you know, the law board staff conducts themselves with a high level of integrity, and you know, we really try to make sure that there's always a fair balance in everything that we do. So.
Is there a motion to accept this case?
What case are we on?
Case number 3, 225 East 134th Street in the Bronx.
Thank you.
So move.
Thank you, Mr. Hilton. Is there a second?
I'll second.
Thank you, Ms. Roslin. Mr. Rivera, can you please pull the board members?
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Rosen,
Yes.
Ms. Otto,
Yes.
Ms. Rajan? Yes. Chairperson Patino?
Yes.
6 in favor, 2 absent.
Thank you. Next are the cases on the summary calendar. We usually vote on these cases as a block. The cases are 210 Cook Street in Brooklyn, docket numbers TR 1418 and PO 0157. 85 Franklin Street in Manhattan, docket number TR 1451. And 647 Broadway in Manhattan, docket number TR 1455. Are there any comments on these cases? Is there a motion to accept these cases?
I will move.
Thank you, Mr. Rajan. Is there a second?
Second. Second.
Thank you, Mr. Hilton. Mr. Rivera, can you please poll the board members?
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Rosen,
Yes.
Ms. Otto,
Yes.
Ms. Rajan? Yes. Chairperson Patino?
Yes,
6 in favor, 2 absent.
thank you. So we'll now turn to vote on the cases on the master calendar. The cases are removal cases, and we usually vote on these cases as a block. The cases are 1139, 1141 Manhattan Avenue in Brooklyn, docket numbers LE 0737 and RG 0219. 15 J Street in Manhattan, docket number LE 0741, and 62 Washington Avenue in Brooklyn, docket number LE 0742. Are there any comments on these cases? Is there a motion to accept these cases?
I'll make a motion. So moved.
Thank you, Ms. Roslin. Is there a second?
Second.
Thank you, Mr. Hilton. Mr. Rivera, can you please pull the board members?
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Rosen,
Yes.
Ms. Otto,
Yes.
Ms. Rajan? Yes. Chairperson Patino?
Yes,
6 in favor, 2 absent.
thank you. So this will conclude our June 15, 2023 Loft Board meeting. The July 2023 board meeting has been canceled due to a scheduling conflict. So our next public meeting is scheduled for September 21st, 2023. Thank you.